Money FM 89.3. Best of breakfast. Morning Shot.
Welcome to Morning Shot. Leader of the Opposition and Workers' Party Chief Pritam Singh has announced his intention to appeal his conviction and sentence. This comes after he was found guilty of 2 charges of lying to Parliament over false testimonies he gave to a committee of privileges during its inquiry into former WP Member of Parliament Raeesah Khan's conduct, and handed the maximum fine of $7,000 for each of the 2 charges. Deputy Principal District Judge Luke Tan says the WP chief had willfully lied and that he never wanted Ms. Raeesah Khan to clarify the truth about her false claim in Parliament about accompanying a sexual assault victim to the police station. For more insights on the latest developments, we're joined by Benjamin Joshua Ong, Assistant Professor of Law at Singapore Management University. Good morning, Benjamin.
Morning. Thank you very much for having me.
You're very welcome. Let's talk about the sentence then that was meted out to Mr. Singh by the judge. Can you explain, first of all, the factors the judge considers when determining the amount of the fine and whether the maximum fine for each charge was an expected outcome?
Sure. So the approach that the judge would have taken is pretty much the same as the approach any judge would take in any criminal case. Which is to say a lot depends on the facts, and it's impossible to come up with a comprehensive list of factors the court would take into account. But broadly speaking, the court would first consider what's the range of possible punishments that the law allows for. In this case, we have a fine or jail, and I suppose one of the biggest choices the judge would have to make is whether to impose a fine or jail, or both. Typically, imprisonment is reserved for the most serious cases, typically when there's demonstrable harm or, a harm to a very great public interest or to an identifiable victim. As for what punishment within the range, so in this case, the range of fines from $0 to $7,000, the court would consider matters such as the relative seriousness of the offense, which is difficult because this is the first case of its kind, right? So typically the court would consider this offense and how serious it is compared to in other past precedent cases, but here we don't have any. Other factors would include, the need for deterrence, whether it's deterrence that comes to the fore or whether it's the sort of offense for which, if it's a young offender, rehabilitation will be the dominant consideration. Things like whether it's the accused person's first offense, whether they cooperated with the police and investigations, remorse, that sort of thing.
All right, yeah, thanks for contextualizing that for us. In this case, Judge Tan noted that Mr. Singh did not actively take any action after the first meeting to ensure that Ms. Khan would clarify her lie in Parliament. In your opinion, to what extent does this inaction undermine Mr. Singh's defense?
Yeah, so when you're drawing an inference from inaction or an omission, what the court would have to consider is what would one naturally expect someone to have done in those circumstances? Right. And yet they did nothing, right? So how do you determine that? First, you consider what sort of person is this, right? In this case, given that he's in a leadership position, what would he be expected to do in that capacity? And the court also considered, by contrast, it found that he was proactive about some so-called Muslim issues that Ms. Khan raised in Parliament, and he proactively urged her to correct those. So the question is, why wasn't he similarly proactive as to this issue? And the court also went into quite some detail about what precisely was said at the meeting and what precisely was not said about whether you would expect him to follow up on this particular incident versus what he did. Now, of course, a lot turns on the particular facts, and I do note that the facts or the evidence may be reappraised by the High Court when the matter goes up for appeal. But it does make a great difference. It is pretty important to see everything in context and to consider all the instances at which whether you would expect him to take action versus whether or not he did, and whether there's a plausible explanation for his alleged inaction.
Yeah, sure. Just continuing on with this point, keeping in mind that Mr. Singh is a seasoned political figure, does the court weigh the experience and knowledge of the accused when determining whether he acted with intent of not taking action after he found out about the untruth? Does his position as leader of the opposition play a role, you think, in the outcome of the case?
Yeah, probably. So I've had a look at the court's oral judgment, which is, by the way, unusually detailed. It's 153 pages long, and there could even be a more detailed written judgment in future. So like I said, so typically the court would consider, is this a circumstance where a reasonable person in this person's shoes would take action, and yet they didn't? And of course, this person's shoes are not just any ordinary person's shoes, right? The court would consider, for example, if he is a very experienced politician, one would naturally expect him to, be savvy about certain matters, and one might expect him to take a certain course of action at certain junctures in the saga, and yet he didn't. Whereas if this was a person who was relatively inexperienced or, a lay person, that could well be a plausible explanation for inaction. And as the position of leader of the opposition, I suppose what's relevant is not so much that he's leader of the opposition, but rather his leadership within the party, right? Such that the party's reputation is in his hands, and therefore, you would expect him to say or do certain things at certain points in time. That I suppose would have been weighing on the judge's mind.
All right. The court also gave full weight to the WhatsApp message from Ms. Khan to a group chat with former WP cadres Lo Pei Ying and Yudhishthira Nathan after her meeting with Mr. Singh on August the 8th, 2021, in which she mentioned that the party leaders, quote, agreed that the best thing to do is to take the information to the grave. The question here is, how crucial is this kind of evidence, and how does the judge determine whether or not that piece of evidence is true?
So I take it that when you say this kind of evidence, you mean, written evidence, this WhatsApp messages which exist in a written form that were, this exchange took place immediately or very shortly after the meeting.
Sure.
So typically this is important, right? Because first, there's a clear record as to what precisely was said. And second, because these messages were exchanged so close to the meeting, whatever was said in there would reflect what was fresh in the mind of Ms. Khan and Ms. Low and Mr. Nathan as well, right? As opposed to something an exchange that took place many days after, when events may have faded, recollections may have, people may misremember certain details. So yeah, this sort of written evidence can be pretty important. That is not to say that it is necessarily reliable just because it is written evidence. So how the court would determine whether a piece of evidence is reliable? So a few things. First, the court would, of course, have to consider that these are WhatsApp messages, relatively informal. It's not necessarily a well-thought-out statement. If there are ambiguities in this message, allowance has to be made for the fact that people take a more informal tone. Perhaps they may have a shared, they may use certain words in a certain sense based on their shared understanding or pattern of communication, like, how we communicate with our friends. We'll have certain, short forms, abbreviations, and so on.
Sure.
And so a big part in assessing these messages would be what the witnesses say in court, because that is their chance to clarify or to explain the context or what they meant by this and that message. Now, of course, these aren't the only pieces of evidence, and another big thing the court would consider would be, considering whether these pieces of evidence are corroborated by any others, considering whether these pieces of evidence, the messages are internally consistent, do they contradict themselves, and so on.
Yeah, you did touch briefly just then about witnesses who testified, and Judge Tan did allocate a significant proportion of time to talking about the reliability of that. How does the court assess the reliability of testimony when there are conflicting accounts?
Yeah, thanks. So it is, again, it's a very fact-specific exercise. So to begin with, we note that the defense had tried to impeach certain witnesses, Ms. Khan at least, right? So impeachment means to argue that the witness is generally unreliable and can't be trusted. Now, it is true, of course, that Ms. Khan told a lie in Parliament, but that doesn't necessarily mean that she was lying in court, right? Just because someone lied once doesn't mean they're necessarily lying again. So the court would consider a few things. The court would consider whether the evidence that each witness gave was internally consistent, so did they contradict themselves, as well as whether it's externally consistent, meaning is it contradicted by any other piece of evidence? Right? When we're talking about, like I said, an omission or an inaction, the court would have to consider is there evidence that would explain that inaction, right? Or is there evidence that perhaps would paint that inaction in a more damning light? So, for example, the court made much of the fact that Mr. Singh had this, what the court described as inaction, vis-a-vis this issue, as compared to his relative action on the so-called Muslim issues that she discussed. And I think the court also said something about how there was, I think the court said something like a flurry of activity leading up to in October and November compared to a relative lack of activity before that. Now, of course, all this is very complex because the court would also have to consider, these are people, these witnesses are recalling events that took place months or weeks ago, right? Not everyone recalls things perfectly. So if, for example, just because you didn't remember what the weather was like on that day doesn't necessarily mean that you can't be trusted. But on the other hand, given the seriousness of this matter, you would expect that to be fresh on the accused person's minds, or not just the accused, but all the witnesses' minds. There were also issues about the deletions of certain messages by Ms. Low and Mr. Nathan, I believe. And again, the court would have to consider, was there a reason for this, right? So they said the reason was something like a fear of their phones being hacked or something like that. And the court would have to consider whether that is a plausible reason and whether these alleged deleted messages, if they had been present, would they have made a difference to the court's assessment? So it's a very fact-sensitive exercise. But and one more thing is, in theory, the witness's demeanor in court. Now, of course, it can be very difficult to assess people's demeanor, but it could be something like if a witness is very straightforward and has no hesitation in describing one thing. But then when it comes to another thing, they turn shifty, there's a lot of and that can be a basis for inferring something about their credibility as well.
Sure. If we take an objective look at this case in terms of the significance of it for future cases of a similar nature in reinforcing the importance of being able to substantiate claims made in Parliament, especially when it's got to do with anecdotes, for example. Yeah, could you explain that significance? And should there, secondly, be more specific guidelines to regulations surrounding parliamentary privilege?
So, to take the second point first, I recall you had me on this show a while ago to talk about parliamentary privilege generally, and we were talking about how, there's, so the idea of breach of parliamentary privilege can encompass a wide range of conduct, but it's always been very well established that telling an untruth to Parliament is a breach of privilege. So I don't think you can get more specific than that, right? And of course, we were talking about how, when we consider an untruth, it's not untrue if, for example, you just say that I heard something, but I could be mistaken, or if you discuss a hypothetical, right? I'm concerned that this may happen. I have heard anecdotal reports. Whether or not these are true, this raises the broader issue of principle. Should the police be more sensitive when dealing with victims of sexual assault, et cetera, et cetera? So should there be more specific guidelines? No, I don't think so. And you also said the significance of this case in reinforcing the importance of, telling the truth and being able to substantiate what you said. Yep. Yes. So before this case, all the instances of untruth told to Parliament, including by Ms. Khan herself, were dealt with by Parliament itself. Parliament has the power to do that when the untruth or the the abuse of privilege is committed by a member, Parliament can Parliament can itself take action and impose a fine or a suspension or, interestingly, by the way, even jail time. But this is the first time a case has gone to court, right? And of course, that has rather more significant implications, connotations, it being a criminal record arising from a conviction, if convicted, imposed by a court. And you can kind of see why Parliament chose to refer this case to court, right? Because Parliament has the discretion to deal with the matter itself or to refer it to the public prosecutor who may then bring criminal proceedings in court. Parliament probably thought this is even more serious a lie because it's not just something spoken off the cuff in Parliament, but rather it's in the course of a formal investigation where the witnesses are specifically sworn on oath to tell the truth. It's a very formal investigation. You should know that it's especially serious. And yet you allegedly lied. So that's probably what Parliament had in mind.
If we cast our minds back to 2022, Benjamin, Parliament had indicated then that it would defer decisions on parliamentary sanctions on WP MPs Faisal, Manap and Sylvia Lim until the conclusion of criminal proceedings against Pritam Singh. Should the public expect potential legal proceedings in that case or something less serious? It's
hard to say. If you ask me, I'm pretty sure that decision would have to be further deferred until the outcome of the appeal, right? Mr. Singh has made it quite clear that he's going to appeal, and I think he's probably going to go forward with that appeal. That's significant because, anything could happen at the appeal. The appeal court would have the power to consider not only whether the district court in this case got the evidence wrong, but also whether it got the law wrong. So, the appeal court could well consider the interpretation of that law, the meaning of the word willfully, telling a misstatement. The appeal court would also, go into great detail, presumably about the lower court's assessment of what was said, its assessment of credibility, whether it gave undue weight to a piece of evidence or, was too quick or, didn't go far enough in considering possible alternative explanations. So certainly Parliament would defer its decision till then. And I can't recall the details off the top of my head, but a lot would also turn on what precisely was said by Ms. Lim and Mr. Faisal.
Yeah, Benjamin, sorry to interrupt that. We've almost run out of time, but I do have one final question. With the GE just months away, the sentence had put a question mark over Singh's political future, but the Elections Department has confirmed that the sentence imposed on him does not reach the threshold to disqualify him as an MP. He himself has said that if anything, he would step up rather than step down. What do you make of potential domino effects this case might have on the WP?
Wow, it's harder and harder to say. I mean, at the risk of speculating, there would certainly be some supporters who would, from the get-go, have been even more solidified in their view to support the Workers' Party by the Sulaga. They may think that even if Mr. Singh did tell a lie, that this response to refer him to the public prosecutor was disproportionate. Of course, there would be those who form the opposite conclusion and consider this cast doubt in the Workers' Party's credibility. It's really hard to say, and especially since you got the appeal pending. What is for certain is that what voters make of events like this, or the conclusions that voters draw, would certainly differ from block or from group of voters to group of voters. Just because he's been convicted and sentenced for a particular fine doesn't necessarily mean voters would go against him. For some voters, it could be quite the opposite.
All right, Benjamin, thanks for your time and helping us deconstruct the latest developments on this case.
And thank you very much for having me. And have a good day.
Yep, you too. That was Benjamin Joshua Ong, Assistant Professor of Law at SMU. This is Money FM 89.3.
To listen to more great interviews, download our podcasts at audio.sg or download the audio app. That's AWEDIO, audio at the App Store and Google Play.